The reason why EFF exists is because when technology changes, there are always forces in society at the level of corporations or lawmakers or whatever trying to relitigate those rights. For example, people saying, oh, now that encrypted communications exist, we need to rethink your right to privacy. It's too dangerous for people to have the right to private communications anymore. Or alternatively, now that these cool technologies exist that law enforcement can use to track people around a city, now you shouldn't be able to have your freedom of privacy and dissociation anymore, because it's so much more convenient for them to be able to follow you around. And EFF's real point is saying, no, your rights are your rights. And when technology changes, then corporations and the legal system have to continue to respect your rights. EFF, which stands for Electronic Frontier Foundation, is a digital rights organization. And when I say that to people, then if they're not familiar with EFF, then their response is, what does digital rights mean? And the answer is kind of nothing. The answer is it's a sort of made up term. Your rights are your rights. Your right to free speech, your right to privacy, your freedom of religion. Those things are your rights. And the reason why EFF exists is because when technology changes, there are always forces in society at the level of corporations or lawmakers or whatever trying to relitigate those rights. For example, people saying, oh, now that encrypted communications exist, we need to rethink your right to privacy. It's too dangerous for people to have the right to private communications anymore. Or alternatively, now that these cool technologies exist that law enforcement can use to track people around a city, now you shouldn't be able to have your freedom of privacy and dissociation anymore, because it's so much more convenient for them to be able to follow you around. And EFF's real point is saying, no, your rights are your rights. And when technology changes, then corporations and the legal system have to continue to respect your rights. You asked when it was founded, which was in 1990, which was a long time ago, and I was not around for a lot of that history, so there's lots of parts of it that I don't know a whole lot about. But it's interesting. It's grown and transformed in some ways over the years. But that mission of teaching both the courts and policymakers about how your rights and freedoms work in the technological world, that has stayed consistent.
So how does EFF, the Electronic Frontier Foundation, defend and promote internet civil liberties?
We sort of think of our program work in three main buckets, which are tech, law, and activism. So for the tech, we actually have programmers on staff who are creating tools that you can use to protect your privacy.
Like software?
Yes. They're kind of the most famous thing that we make is a browser extension called Privacy Badger. That, you know how when you go to a website, there might be these like tracking tools from other websites that are following you
like
there.
Like cookies?
Yeah. Mm-hmm. Or like the way that a lot of sites will use the Google Analytics tracker in order to measure the analytics, or like ad companies that also then get all of this access to your activity. So you can use this tool called Privacy Badger that shows you on any given website how many of those trackers there are, and lets you turn them on or off, give them permission to see what you're doing or not. And we could talk about the other tech projects too, but so that's what our technology team does. And then we have a legal team. We have many lawyers on staff who do what's called impact litigation, where they're taking on cases specifically for the purpose of effecting change in making sure that the courts respect your civil liberties. And then finally is the activism team, which I'm the head of, which is about empowering people to defend their rights to policymakers. We do a lot of stuff targeting Congress, but to other people as well. And a thing that we've become increasingly focused on over the years is looking at how the decisions that companies make affect your right to privacy just as much as the decisions that Congress makes.
Oh, that's interesting. I really want to talk to you about that because I think it's a really interesting part of this discussion right now is the public versus private censorship and banning and all that, what it means. But great. So what kind of cases does EFF look to become involved in?
And I should preface this by saying I'm not a lawyer, and maybe you should get somebody from our legal team on here one day. But these are cases where we need somebody explaining to the courts how technology works in order for them not to make decisions that have huge unintended consequences. I'll give you one of our big cases that went on for 10 years and was finally just recently settled, has to do with your right to fair use. The facts of the case, as I understand it, were a woman put a video on YouTube of her toddler son dancing to "Let's Go Crazy" by Prince. And Prince's people had the video removed from YouTube under the Digital Millennium Copyright Act, which we can talk about in a minute. One of the things that came out of that litigation was the court saying that when a rights holder, like Universal Music Group or Warner or whoever, does a takedown notice, they have to analyze whether the use was protected under fair use or whether it would be protected under the fair use doctrine. And in this case, and we can talk more about fair use if you like, but in this case, it very clearly was fair use. It was not hurting, it was not impacting the audience for the Prince song in any way. And it was just this tiny little 45-second video or whatever it was. This is very clearly the kind of use that you should be able to do without having permission of the copyright holder.
So that's what you guys do, is you, and correct me if I'm wrong, you help people who need to fight these kind of cases one way or another, and you go in there and help them?
Yeah, right? Yeah. And there's, in a number of cases, we are actually the lawyers for the...
Yeah, your legal team, you were saying, right?
People in the case, right. So, like, that's what it was in Lenz versus Universal, which is the case I was just talking about. We were part of Stephanie Lenz's legal team. There are also a number of cases where we file an amicus brief. So we're not actually the lawyers in the case, but we are saying to the courts, look, there's an important thing here that you need to make sure that you get right. And this is all kind of like, this is kind of how impact litigation works. It's looking for the cases where you can try to make good law or fix bad law.
How does that work? Do you guys go to Congress, or how do you become involved in helping the lawmakers make the right choice if you're not actually the lawyers.
Well, so we can talk about Congress in a minute, but this is just in the realm of the courts. I can give you another example of a case that shows where like the court's interpretation of the law becomes really important.
Sure.
I do, in addition to the other stuff I work on, I help some with our patent activism. There is a really important Supreme Court decision from 2015, I think. I might need to look that up, which is called Alice v. CLS Bank. What the Supreme Court said in the Alice decision is that an abstract, unpatentable idea does not become a patentable invention just because because you perform that idea on a computer.
What do you mean?
I'm trying to think of I'll give the actual example in Alice v. CLS Bank. It was essentially the patent in question was describing these kind of business processes that had existed for a long time about how you process these certain types of transactions. And the patent said, doing all of this stuff that is understood, that is not a new invention, that is just a routine business practice, but doing it on a computer. And that being the thing that turns it into a patentable invention.
Because it's now a tangible thing, like a tangible software or something like that? Is that
sort
right?
of? Like, in our view, it shouldn't make it a patentable invention. Software patents, on the whole, have I always think that you should, if you wonder how useful software patents are, you should just talk to a software developer and ask them what they think about software patents. And I've talked to so many developers, even ones who have patents in their name, who will just kind of laugh at the whole concept of software patents.
Well, we talked with Marta Belcher about just this software patents, also patents in regards to blockchain and technologies built on blockchain. And she did talk about that, how some big companies, I don't want to get this wrong, I think it was Twitter, maybe not, but that they actually do hold several patents, but because apparently this is the consensus in the community, is that it's still open use. They allow anyone to use it, but they do technically hold the patents, but they don't enforce it.
Yeah, this is an interesting issue, and I'm glad you had Marta on because she, I'm sure, could talk at much more length about this than I can. There are a number of ways that people have tried to have patents and also stave off kind of the worst effects of software patents in the form of these kind of open licensing agreements you're talking about. And Tesla famously did this.
Oh, right.
A few years ago, where they put out their press release saying that they are not going to sue anybody for patent infringement on these certain patents. These are... The fact that there's so much interest in these kind of different licenses or waivers or ways of kind of hacking the patent system, that's the title of the paper that Marta worked with on us. The fact that there is so much interest in that space points to the bigger problem of this sort of fundamentally broken patent system. And so in the Alice decision, in our view, the courts brought a little bit of fairness to this fundamentally broken system by clarifying that these patents on unpatentable ideas don't become a patentable invention just because you say doing it on a computer. I could not get you could not get a patent on hosting a talk show. And you also shouldn't be able to get a patent on hosting the talk show just because it's a talk show on the internet, as opposed to being a talk show on TV. And so you have this precedent set by the Supreme Court, but these things are tricky, and sometimes even the neither side in a patent infringement case is saying the thing that we think actually needs to be said about how it's not just that the person wasn't infringing, it's that this patent wasn't valid in the first place.
Gotcha. Well, so I do want to ask you about this more, but I do want to finish up talking about EFF just for good context.
Okay, so we talked about the first two branches of EFF. Wait, is that where we left off?
Yeah, you told me the three, which is, go ahead and recap it again.
Yeah. So the three kind of buckets of EFF's work are our technology, which we've talked about, and law, and I've given you an idea of what our legal team does, and then activism, and that's the part of the organization that I'm kind of in charge of, and that's really about empowering people to speak out to defend their rights, be it sending messages to Congress to tell them to vote for or against a certain bill, or, well, speaking of patents, we just recently had a campaign where we encouraged people to write letters to the patent office. And then we're increasingly looking at ways that we can kind of use our community and use this multitude of angry nerds that read our emails to affect change at corporate practices too. We just recently launched this campaign called Fix It Already, that the purpose of it is to urge internet companies to make these, most of them are actually really simple changes that they could make in like an afternoon to protect your privacy. It is absurd in the year 2019 that you cannot make your contacts on Venmo private.
You can't.
Right.
You can make your
transaction history private, but you can't make your list of contacts private.
Oh, that's interesting.
And that's a change that they could make so easily.
What's their reason for not doing that? To encourage a community?
I don't actually know. Which isn't to say that they don't have a stated reason. Just I don't actually know what it is.
Interesting. Well, yeah, okay. Well, on this, so let's talk about patents then, because I also talked with Marta Belcher about patent trolls. So she talked to us about that, but from your perspective, are you able to share your thoughts on that?
Yeah, trolling is a serious problem.
What is it?
A patent troll is, it can be, sometimes a lot of debates happen over the subtle definitions here. A patent troll is a company that exists only to amass patents and sue or threaten to sue people for infringement, that has no business model besides suing people or threatening them.
That is their
asking for
business.
money. Yeah. We just recently put up on our site an interview with this person who would have had his entire business sunk by a patent troll if it had not been for that Alice v. CLS Bank decision that we were talking about earlier, where a judge correctly had that patent invalidated under the Alice decision. When we talked to this guy, and he described getting this demand letter in the mail, and saying, I think it might have been $30,000 that they were asking him for when he was just this new startup with a staff of like one or two people. And there was no way he could have afforded to pay that. And the patent, and it's a classic example of the kind of patent that both under the law and just kind of under basic common sense shouldn't be valid.
Are you able to say?
Yeah. It's this company called My Health. And again, they have no business model. They have no product. What they have, or maybe what I should more accurately say they had, is this patent on remote patient monitoring and diagnosis. So on using a phone or video system or whatever to talk to a patient remotely and give them some kind of diagnosis remotely.
And it's an app?
It's nothing.
Oh.
They have no business model. They have no app.
Oh, it's just an idea.
Right.
Can you elaborate on that?
Sure. Here's a story that I think is a pretty good encapsulation of the patent trolling problem. There's this man who lives in Omaha who EFF has gotten to know over the years, who had a telehealth company. It's a company called My Vitals. And it's a company that you can use for kind of remote patient diagnosis. One day, when his company was kind of just getting started, when it had been around for a few months, he got this demand letter from a company called My Health. My Health said that it owned the patent on what his company was doing. Now, when you look at the My Health patent, it is remote diagnosis. It is exactly that. It is the practice of a doctor talking remotely to a patient and giving them some kind of prescription. This is just a classic example of a patent that is sort of an abuse of the patent system, because this is a practice that has existed in some form or ever for a long time. But they filed this patent that claimed doing this practice, that it has existed for a long time over the internet. And so Justice, that's the name of the gentleman, Justice Decker, he received this demand letter for, I think it was $25,000 when he was this entrepreneur who had just started a company with maybe 1 or 2 employees. He could not afford to pay that. Oh, and by the way, they were also suing or sending these similar demand letters to all of his competitors, to all of the companies doing this same kind of work.
And he wasn't in the market at all.
Well, no, he was. But the patent troll,
No, that's what I mean, the patent
this
troll.
company,
Yeah,
My Health.
They were not even in the market. They weren't trying to develop anything. They just held the patent.
Right. They were not a practicing company. You can look on their website and there's no product. There is no service being offered. Their entire business model was just sending people these demand letters threatening to sue them and getting these licensing payments from them. Oh, and by the way, it's such a funny detail. They were at the same time also doing trademark trolling. They were also threatening people for using the phrase "my health." It's like, in EFF's view, these companies, they're kind of an unfortunate side effect of a loophole in the law. The reason why the patent system exists, and it says this right in the Constitution, is to promote innovation. These companies that don't do anything except for sue actual practicing businesses are like, there's no innovation happening there.
Right, because they're stifling them.
Right. So we talked earlier about the Alice v. CLS Bank decision. Fortunately, the My Health patent was invalidated under Alice.
Oh, so it was fought successfully.
Right. And so Justice still has his business, and he is still going along.
How are companies like that, I guess, legal?
That is a very good question. And like, we have tried over the years to get in place some good reforms to make patent trolling harder. Lots of patent trolls' tactics, when it really comes down to it, are just taking advantage of the fact that for a practicing company on the defending end of a patent infringement suit, fighting that case is going to be very expensive. So they'll offer them this fee that is a lot of money, but still less money than fighting that in court might be. So there have been various attempts in Congress over the years to essentially make patent trolling harder. And there have been some important wins. We've talked, of course, about the Alice v. CLS Bank decision already. These low-quality software patents are kind of the perfect fodder for trolling because you can find so many practicing companies that supposedly infringe on them.
And they're probably not at stages where they have a ton of capital where they can go to litigation over this.
Right.
They just have to settle.
Right, exactly.
I've heard the same thing with ADA compliance, that there are firms that go specifically after small to medium-sized businesses that have, ADA infractions. Is that the right word? That just aren't 100% compliant. Same with, this is probably on a much lesser scale, but domains. I know people will, buy a ton of domains just to hoard them. So people have to pay them when they want to use it. But it's interesting. So what makes a patent legitimate or illegitimate?
That's a good question. And I should say again here that I'm not a lawyer. But what a patent is supposed to be on under the law is, one, an actual invention, like not just the idea of hosting a talk show or of doing remote patient monitoring or whatever, but an actual invention. Two, it's supposed to be something that did not exist previously, that was not commercially available, that you can't find existing documentation for how to do at the time that the patent was filed. And then three, the patent application itself should explain how to do the invention. And this is where you get to what's supposed to be the purpose of the patent system. Is it's essentially this bargain that society makes with an inventor, where the inventor gives society this information about this new process that they've discovered, whatever it is. And in return, society gives the inventor a temporary monopoly on that invention, so that they can, one, make money for it, and two, so that they can scale it.
Because they're the ones that put in the risk, the work, the research and development. Is that what you're saying? So therefore, they should be able to reap the benefits for at least a little while before other people start jumping on that.
Yeah, there's I think questions about without that patent, again, and this is in this kind of idealized version of the patent system that we're talking about right now, how you would effectively be able to scale, how you would be able to, if you were operating only on trade secrets, only on if you're operating only on this secret thing that you know about how to improve a certain product in some certain way that nobody else knows, then it would be hard to scale that business beyond just you having your little shop on the corner where you're selling whatever this thing is. But again, if you take those ideas of what the patent system is supposed to be, one, that it's supposed to be on actual inventions, and two, that the patents are supposed to be a trade of actual useful information to society, and then you look at these sort of low-quality software patents that we've been talking about, you realize that something is very wrong. And this is why I said this a second ago, that when you ask that question to professional software developers of whether the information in the patent literature is useful to them or not, the answer is that it's not. Like the My Health patent is a good example. You look at that patent application and it describes this process of the remote monitoring or whatever, and it has these flow charts of, doctor contacts patient, arrow goes over here. That's not useful information.
Wait, so that's
Because the idea of that business, that's really easy to think of.
right,
The hard part is doing it.
right.
But when you have these low quality software patents, you're essentially rewarding the idea more than you're rewarding the work.
Right. That's it. Okay.
Here's a funny side note about the My Health patent. Where it originally came from is the University of Rochester. And that's pretty common for these software patents that end up in the hands of trolls. A lot of them actually originate at universities from research that was funded by the government.
Really?
Yes.
How is that?
There is a law that was passed, I think, in 1981 called the Bayh-Dole Act that allowed people who file patents people who develop inventions as a result of government funding or government contracts to be able to patent those inventions and license them out. And there are a few universities that have made a lot of money on this system. And there are lots that don't make any money on this system and in fact lose money on it, but still file lots and lots of patents on government-funded research and license those patents to third parties.
Is that something that you guys work to make, lawmakers, whoever, more aware of?
We have tried. It's a complicated issue. If you actually go to reclaiminvention.org, you'll see this little site that we put together about this problem, where we encourage people, including students, faculty, etc., to reach out to their university leadership and say, hey, let's just at very least make it a part of our patenting process that when the university is licensing a patent to a third party, they will do a little evaluation of that third party and whether it's a troll. I certainly don't want to paint the universities in a bad light here. And in fact, a number of them do try to take certain precautions to make sure that the patents are ending up in the hands of companies that are actually going to enact the invention in the patent and are not just non-practicing entities. But yeah, it is a big and complicated problem.
Can you talk to me about, on the topic of intellectual property, talk to me about copyright in the digital space? Copyrighted materials.
Yeah, EFF does a great deal of work in the area of copyright. And in fact, it was kind of EFF's work in copyright that first sort of brought me to EFF. Before I worked at EFF, I worked for an organization called Creative Commons that you're familiar with.
They provide free for public use images, videos also, or no?
Yeah, well, they don't provide that material by and large, but what they provide is the kind of legal framework for sharing it.
Gotcha.
These licenses that say anyone can use this material as long as you do X, Y, Z.
I know that there's some websites out there that provide I'll just use images as the example, but they'll say, anything on this website or in this section or whatever it is under Creative Commons, which means it's free to use.
Right, right. And I mean, we could talk about the different types of Creative Commons licenses. There are 6 different licenses that each have kind of slightly different rules about what people can do with that material. And sometimes those things get just unfortunately sort of lumped together, and there's this idea that, just Creative Commons means you can do whatever with it, when in fact, like some of the licenses have a requirement that you can't use it commercially, and there are some restrictions and things. But it was while I was at CC that I started thinking a lot about copyright as a kind of public policy issue. And EFF was definitely one of the organizations that I admired as being kind of on the vanguard of that. Here is when a friend of mine asked, why is copyright important? Why is it so important that it is a thing that EFF devotes a lot of work to? My response to that was, because copyright is increasingly used as a tool of censorship. And if you care about people being able to speak out freely on the internet, then you need to recognize copyright's history as a tool for silencing people. And I'll give you, this is by no means the most treacherous example of that, but this is a pretty good example that shows how copyright can be exploited for the purposes of censoring certain speech. There was, as a part of a few years ago in San Francisco, there was a citizens initiative. I don't even remember the details of it exactly, but having to do with Airbnb and other kinds of apartment sharing apps. There were people trying to pass an initiative to make it harder, I think, to have just a dedicated Airbnb apartment that doesn't have any permanent tenants in it. And for the record, I have no opinion or position about that measure. But somebody made this ad that they put online, and they put on local TV channels and things, that used this sort of short parody of Hotel California by the Eagles. They called it Hotel San Francisco. Again, we were talking earlier about fair use. This was just very, very obviously fair use.
What was
this use of the Eagles song, or the use of I wouldn't even call it the Eagles song. I'd call it more like a sound-alike in the ad. It's just it's fair use. But the way that the Digital Millennium Copyright Act works is that the rights holder went to YouTube and said, you have to take this video down because it's copyright infringement. What happens after that is that the uploader, if they want, sends a counter notice that says, no, this is not copyright infringement. And then the copyright holder has, I think it's 10 days in order to sue the person for copyright infringement. And if they don't sue the person for copyright infringement, then the video can go back up. They sent this takedown notice a week before the election.
What do you mean the takedown notice?
They sent this takedown notice to have the video removed from YouTube.
Oh, so all they had to do was file a counter and wait it out?
Right, but that's the period of time when the speech was important.
Right. Oh, so they have to take it down during that time.
Right. So very clearly the purpose was just to have it be down during the time when it was intended for people to watch it. And these are, in issues of copyright infringement and in other sorts of issues having to do with online speech too, be it defamation or whatever it is, you have to very carefully look at the ways in which reporting and takedown mechanisms can be abused. Otherwise, you risk doing more harm than good.
Can you talk about, I think it's the EU that is proposing a law where, what is it? Social media platforms or websites have to have some kind of copyrighted material filter or something like that. You can probably explain better than I can.
It's a funny thing because the proponents of Article 13 will say up and down, no, it's not about filters. But when you look at what the proposed law that they're going to be voting on soon says, is that having these copyrighted materials be up on your social media website for any amount of time is illegal.
Holds you liable as the website owner.
Right. There's no way to do that at the scale of a YouTube or a Facebook or whatever without using some kind of copyright filtering system.
What is a copyright filtering system?
The most kind of readily available example that most people are sort of familiar with is on YouTube. If you've ever tried to go to a YouTube video and instead gotten the little frowny face version of the YouTube logo that says this video has been removed due to copyright infringement. So here, I'll try to explain at least a little bit of how this works. A second ago, I was talking about the DMCA notice and takedown system, where I have something online that you say infringes your copyright. You can tell the platform to take it down, and then they do, and then I can file a counter notice. And then if you don't actually sue me for copyright infringement, then the platform can put it back up. That's how it's supposed to work under the law. What YouTube and increasingly other platforms have done too is they've kind of added an extra step that happens before that process, where you have uploaded all of your music to YouTube's copyright filtering system, and I upload a video that might have a bit of your music in the background of it. You can set with YouTube specific instructions about whether you want it completely removed, whether you want it demonetized if I'm getting ads on it, whether you want it monetized and then the money going to you.
Oh, that's interesting.
Yeah. And so YouTube has created these features for reasons that make a certain amount of sense from a business perspective, that they want to court favor with the big media companies. There was a period of time before Content ID when YouTube was the object of a lot of criticism by those companies, and it still is to a certain extent. And YouTube wanted to develop those partnerships with all of the big movie studios and all of this stuff, so that they really developed this system as a favor to Hollywood. Now, and this is most immediately happening in the EU, but it's going to be happening in the US as well. People are saying that this thing that YouTube kind of voluntarily did is what all platforms should have to do. And so if you run any kind of website that hosts user-generated content, that everything that gets uploaded has to go through this bot that determines whether it's allegedly copyright infringement or not. YouTube, again, because everybody is kind of familiar with Content ID, it's a good encapsulation of some of the problems here. If you go on our website, you can see we have this whole section called the Takedown Hall of Shame that includes in it some really, really weird things that have happened where Content ID essentially had false positives. There is one of my favorite examples, just because it's so ridiculous, is, you know how sometimes people make like sounds that you can use just for like listening to while you go to sleep or whatever?
Like white noise.
Yeah. So there's this 5-hour white noise video that received 10 different Content ID strikes there were 10 different songs and things in the YouTube filter that this filter believed were copyright infringement. These systems are not perfect, and Google is the best at developing these kind of systems. So moving from where we are now, where it's this voluntary thing that YouTube and Facebook and other companies do kind of as a favor to Hollywood, moving to this system where literally every site that hosts user-generated content has to use these copyright filters, it's going to result in a lot of speech being unintentionally taken down. And then there's this whole other side to it, too, having to do with competition. It's already very, very hard to compete with Facebook and YouTube and Twitter for a lot of different reasons. But creating this situation in which any startup would have to build or license something like Content ID in order not to have this huge amount of potential liability for copyright infringement of its users is going to close out the market.
To only the remaining players.
Right. We're at this weird time now where a lot of the protections, and this is both applies to copyright as well as to 230 other kinds of speech issues. These protections that have allowed Twitter and Facebook to get to their place of dominance. We're now at this point where taking away some of those protections would do far more harm to anyone trying to compete with those companies than it would do to those companies.
Well, I think that's a perfect transition into talking about, because essentially this comes down to free speech, right? So I think that's a perfect transition into free speech. And I want to ask you about your thoughts generally on free speech and free speech online, and then definitely talk about Section 230, right? Right? Perfect. So generally speaking, what are your thoughts on free speech today, on and offline, to start?
Sure. Well, first I'll say, before we even go into talking about Section 230, a big part of why I do this work is because I believe in the internet as this powerful force for community building. The fact that I can go online and have potentially reach just as many people as somebody who has many, many, many times more resources than I have. That is, to me, one of the most important things about the internet, and it's one of the things most worth protecting and defending.
That's why we're here.
Section 230, you really can't, you can't overstate the importance of Section 230 to the internet developing the way that it has. What Section 230 essentially says is that if you run an online platform for speech and somebody goes on that platform and says something illegal, then the liability for that falls on the person who said the illegal thing, not on you. Now, there are some really important exceptions to this. One is, Section 230 doesn't contemplate copyright infringement because there's this whole other set of laws about copyright infringement in the DMCA. It also does not cover federal criminal liability. A platform can't use Section 230 to defend itself from an accusation that it has broken the law in federal criminal court.
What does that mean?
Section 230 protects platforms from, like civil liability for defamation or whatever. If I go on a platform and say something and somebody says that I said something defamatory about them, they should sue me and not the platform where I said it. It doesn't work that way in the realm of federal criminal law. And this was an important distinction in the whole debate over the Stop Enabling Sex Traffickers Act.
And we'll get to that.
Because a lot of the people advocating for that bill, the evidence that they were pointing to for why they thought that passing the bill was necessary was they were really just accusations of platforms breaking federal criminal law. And so actually the Department of Justice, if those accusations are true, could already go after those platforms.
So essentially what Section 230 is it allows I guess owners of websites to not be liable for what their users, commenters, anyone else on their site says that might be considered illegal.
Right.
Gotcha.
And it's interesting, I said a second ago that Section 230 has been so important to the way that the internet is developed. And it's really true. It was passed in 1996, I think. And think about what the internet looked like in 1996 compared to what it looks like now. Today, most speech online is hosted not by the speaker, but by some sort of intermediary. This video, after we're done filming it, is, I assume, going to go on YouTube. You look at the way that...
And podcasts, too.
Oh, okay. Well, and whatever...
It was just a plug on our own show.
And then whatever platforms you upload the podcast to, that's the same idea. The pre-1996 internet was much more about people hosting their own stuff on their own websites. What Section 230 enabled was this interactivity of having these platforms where lots of people can play. It's led to a more interactive, more kind of community-based internet.
Have there been changes to this law recently? Because I have very recently seen a couple platforms specifically say to their audiences, we are no longer able to tolerate any offensive comments whatsoever because whoever they are starting to crack down and I could be held liable.
Yes. So this about just over a year ago, I think, was when SESTA FOSTA, the Stop Enabling Sex Traffickers Act, and the Allow States and Victims to Fight Online Sex Trafficking Act, when those were passed. And you immediately after those laws passed saw some pretty big changes to the internet.
Well, what were those laws?
What SESTA FOSTA essentially does, it's complicated, and honestly, all of the ways that SESTA FOSTA affects online speech, we're still seeing all of those repercussions. Like, they have not all kind of fully formed yet. It creates new liability for platforms, both in civil court and in criminal court, for activities that their users do related to sex trafficking. But it doesn't actually stop there. It also creates all of this liability around prostitution in instances in which there's no indication of force or coercion or anything. We're just talking about prostitution. So it creates this new criminal liability related to prostitution. Here's the problem, and it's like, regardless of what people think about prostitution, it's like, that's not the debate I really care about having. What this increase in liability does is it essentially forces platforms to kind of put their thumb on the scale. It forces them to set up their moderation and filtering practices such that anything that even could possibly run afoul of the law gets deleted.
Because now the website owners are held responsible.
Right. And, we're talking both about civil and criminal liability. We're talking about things that could very easily sink a company. Mm-hmm. And so when you have that huge ramp up in liability, platforms kind of have no choice but to err on the side of censorship. And where this really concerns me is when you think about all of the types of speech that would potentially be censored and that I think you are seeing censored in the name of trying to ensure, to the extent the platforms can, that nothing illegal goes on their sites. And it's pretty easy to see how the people most likely to be silenced are the victims that the law is intended to help.
And how's that?
I want to show you something, if that's okay.
Sure.
This is, I think, a pretty good encapsulation of this problem. Google launched a year or two ago this thing called Perspective API. That the purpose of it is to measure toxicity in online discussions. And the way that it does this is people look at some kind of comment online and they flag it as being toxic or not. And so this algorithm figures out what words, what phrases, what things it should associate with toxicity. And now you can use this API and run comments through it, and it will tell you whether they are toxic or not.
Oh, interesting.
And so look at this list.
Okay.
The statement, "I am a man," is 20% toxic. The statement, "I am a gay black woman," is what, 87% toxic?
Wait, but what does that mean by toxic?
Well, that's the question. So you can see what it's done, right? It's taken these comments where maybe somebody said something racist or sexist or homophobic. That comment was flagged as being toxic. And now the algorithm is going, oh, okay, if it has the word black in it, then it's more likely to be toxic.
Says, like, "I am a white woman" is 77% toxic. "I am a gay white woman" is 80% toxic. "I am a woman," 41% toxic. I mean, they're all toxic.
Right.
They're all just different levels of percentage of toxic.
Yeah. So this, to me, is a good encapsulation of the kind of inherent limits of trying to use algorithms to manage online discussion. So think about this problem and now kind of apply it to how you would create a filter for sex trafficking. Think about what phrases you would try to, what phrases it would flag as potentially being related to sex trafficking and would censor. What types of imagery. And then imagine somebody, maybe a victim of trafficking, going online and trying to tell her story.
Which we've had. We've had on a victim of human trafficking, and we've also had on a founder of a nonprofit helping victims recover.
And so think about the phrases that would be likely to come up in that discussion. Think about the possibility of somebody trying to use one of these platforms to get help.
So you're saying that those websites that are trying to help, that side of the human trafficking conversation, they're the ones trying to help, they could potentially be getting flagged as toxic, whatever these filters are.
Yes. And again, this just goes back to this problem of filters being kind of unable to recognize human context. It's the exact same problem as the copyright bots flagging the white noise, just in a slightly different setting. And it's pretty easy to see what happened to the internet after that law passed. I think it was just a day or two after it passed. Craigslist just removed its personals and therapeutic services sections from its website.
Just to keep themselves safe.
Right. It basically said it is impossible for us to police these sections at scale. So we have no choice but to delete them. There were also a number of kind of niche dating sites that just disappeared. There was a furry dating site that like nobody associated with the site was making much money or anything. And they realized we could be in a huge amount of trouble for something that we don't even know about taking place on our platforms.
Right. Well, I mean, that does bring up a good question of just dating sites in general, really, because isn't that one of the tactics of some traffickers is they just put a fake profile? Either to, like, I've heard this with message boards, but maybe not, I mean, maybe dating apps, but also just message boards where, say, some sick man creates a fake young girl profile and then he befriends other girls that way. And that's kind of how that relationship gets started.
Yeah, I mean, I certainly don't consider myself an expert in how any of those tactics work.
Yeah, but I mean, I feel like that kind of leads every single user-generated content website open to liability, which is...
Yes. And again, we're talking about judgments that it is impossible for a person to make. And now the government is asking these websites to make these judgments at scale.
Yeah.
Oh, and by the way, if anything gets through that shouldn't have, they will be in a huge amount of trouble. When you have that ramp up in liability, the platform has very little choice but to kind of put its thumb on the scale and to kind of err on the side of removing things.
Because what are some of the numbers? It's like there's 1 billion users on Facebook. YouTube uploads 100 hours of video content a minute. There's no way that these companies can have human input on every single so-called offense. So they're creating these filters and these algorithms.
I mentioned a second ago that Section 230 does not apply to federal criminal law. And that's a really important point to kind of underscore here. The things that some of these sites were allegedly doing would have been breaking federal criminal law. And indeed, Backpage, the site that was kind of the elephant in the room during the whole debate about Sesta Fosta, was shut down by the government without Sesta Fosta in place.
Can you say that again?
So this website called Backpage that has kind of been the center of a lot of this debate and was used a lot as the kind of poster child for why we have to pass a law like this. It was shut down by the FBI before Sesta Fosta passed under existing law. What the law effectively does is lowers what was the standard before, which was a website knowingly and intentionally facilitating criminal activity to a much lower standard. The actual phrase is reckless disregard, which is not knowing that illegal activity was taking place, but it's more like knowing that illegal activity could possibly be taking place. The law was passed and signed last year. And since then, a group of plaintiffs have brought a lawsuit against the government, trying to have the law declared unconstitutional. And that group of plaintiffs are the Woodhull Freedom Foundation, Human Rights Watch, the Internet Archive, and 2 individuals. And DFF is part of the legal team for these plaintiffs. The details of each of those plaintiffs are all a little bit different from each other, but the bottom line with all of them is they were all engaging in completely legal speech. And now they don't know what is illegal or not. They don't know where the line is with this new increase in both civil and criminal liability. 2 of these organizations, Human Rights Watch and Woodhull Freedom Foundation, they both advocate for the decriminalization of sex work. And so is advocating for decriminalization facilitating prostitution? They don't know. They also provide various kinds of services, health services, other sorts of things to the sex work community. Is that facilitating prostitution? Again, they don't know.
Didn't you say that the Department of Justice was even urged Congress not to pass this bill?
Yes, that was a weird timing thing because that was, I think it was literally the day before it passed the Senate. The Department of Justice wrote this letter saying, among other things, and we could easily get in the weeds on this in a way that might be less useful, but they said that this would be difficult to enforce, and by also tying in prostitution, was creating targets that they did not actually consider targets. And it's like, I want to be really, really clear that I'm not an expert in trafficking. I have, in the past couple of years, spent quite a bit of time talking to experts in trafficking. And the answer they give when I've asked them, okay, what should Congress do, are pretty surprisingly consistent. It's, 1, reform laws and law enforcement practices that currently make it very, very risky for a victim to report trafficking without putting themselves in danger of prosecution. And 2, address the economic disparities that have contributed to trafficking in the first place. Those are the 2 things. And what Congress did in a pretty significant way is sort of the opposite of those 2 things. And in the process, it's put people in more danger. There was just the other day this Huffington Post article where they interview all of these sex workers who have had to move to street-based work and put themselves in much more danger.
Because they couldn't be online anymore. They
Right.
had to go back to the streets.
Right. One of the people that I've gotten to know as a part of this process is a woman named Kristen Diangelo, who works with the Sex Workers Outreach Project in Sacramento. And she told me this just horrifying story. This was pre-SESTA. She told me this horrifying story of what happened to a trafficking victim after the website that she had been using was shut down. Is that for the first time in her life, her pimp forced her to work the street. And she was attacked, and she was threatened, and she was robbed. And then she came back to the pimp, and he he attacked her too when she, came home empty-handed. These are unpleasant realities to talk about. And yet, if lawmakers want to make a difference in this space, then these are the realities that they really need to confront. Otherwise, they risk doing far more harm than good.
In the what was it? The House hearing. There was a representative that had said, I think she had said something like, "If not this, then what?" And that made me think of who I think it was Thomas Sowell who said, he called "do something politics," which is we don't really know what we're doing. We don't know if it's going to work, but we need to implement laws to just do something. And that reminded me so much of that because isn't it true that the what's one of the biggest anti-human trafficking organizations, something Network USA?
Freedom Network
Freedom
USA?
Network USA. They were against the law, right?
They were, yes. And so was the Sex Workers Outreach Project and a lot of these organizations.
So it makes me think, why did they even pass, why did they pass it?
There's this old joke about a guy who drops his keys in a dark alley. And then rather than looking for him in the dark alley, he walks over to the corner where the street post is and where the street light is and looks there. And his friend asks him, "What are you doing? That's not where you dropped the keys." And he says, "But the light's better here." I think in this kind of legislation, that's more or less what Congress is doing, is it's looking where the light is instead of looking where the real problem is. And it is compelling in a way to imagine that if you do just turn up this liability, then the web platforms can solve the problem. The truth is that the people that they silence, the people that they end up having to kick off of their problems, that makes the problem worse. Another big irony in this entire debate is that a big part of why Section 230 was passed in the first place was to incentivize filtering. Before 230 passed, there was this problem in the courts and this problem was kind of encapsulated in CompuServe and Prodigy. So, this is going back to the 90s, kind of that first wave of home internet services. Prodigy had some filtering of adult content and things because it kind of marketed itself as the more family-friendly service. And so Prodigy was being treated differently when it was sued for defamation than CompuServe was, because courts argued that by doing that filtering, Prodigy was taking on a more active role. There's this great interview you can watch with former Representative Chris Cox, where he tells this story of sitting in a plane and reading a newspaper article about the Prodigy decision and him just shouting out in the plane, "This is absurd," that Congress wanted internet companies to be able to develop these kind of filters and things in order to be able to offer a more family-friendly internet service or whatever it was. And here were the courts disincentivizing them to do so. And now we have this kind of new wave of voices in the internet policy space saying that platforms should filter more And the way that we're going to make them filter more is by giving them more liability.
I know someone in your company had said that, like we're talking about, one of the biggest reasons that you guys aren't for all this government intervention is because it's so difficult to regulate areas that bureaucrats and law enforcement officials don't know a lot about. In this example, technology. We recently had on Yaron Brook, and he had the same criticism on a broader scale on saying that, in the world and all the industries in it, it's so difficult for just a small group of people to dictate the ecosystems and how they're supposed to interact with each other. So I thought that was a really interesting point, because in that context, I think we were talking about like finance and economics and how that affects everything. And then he he's a very pro free market capitalist, and so he was just saying like how can the government try and control this? I think he was talking about in context of like, I think socialism and communism and trying to put the government in charge of anything, and yeah, that was his point, was that these are all very, very complicated industries. The internet, technology, human trafficking, these are all incredibly complex issues, and slapping laws on them arbitrarily, at least in this case, it seems like, with Sesta Fosta, is can do more harm than good.
Well, and it's interesting, and this was to kind of return to what we were talking about earlier about that the ways that corporate policy on the part of internet companies is playing an increasing role in affecting what we can say online. There are sort of these two levels of policy making, and the ways that they interact with each other are sort of interesting. On the one hand, you have web platforms, Facebook, Twitter, etc., and their attempts to remove unwanted speech, and unfortunately the unintended consequences that those policies can sometimes have. Just for one example of that, there are so many examples of state actors using Facebook's flagging system, like for flagging offensive content, to remove the speech of critics by having thousands of people flagging things all at the same time. We've seen this happening in Syria, Russia, Vietnam. And so you have these unintended consequences of platforms sometimes arguably trying to do the right thing. But then on top of that, you have this banner of government regulation. And the ways that can sometimes make what's happening at the corporate level worse. Like Sesta Fosta is a great example, where say what you will about the filtering systems that have been developed by the companies, adding this kind of insurmountable amount of liability to the mix really wrecks that balance. And it's the same with Article 13 and with the copyright discussions. Platforms develop these various processes for how they're going to respond to claims of copyright infringement, like in the form of YouTube's Content ID or whatever. Now, a law dictating that platforms must have those filters and how those filters are going to work will have unintended consequences of keeping certain types of speech, certain fair use off of the internet.
Mm-hmm. I wanted to ask you about free speech in general. in this context, like we're talking about online, what do you think about, I guess, what do you think about private companies, a lot of these social media platforms, censoring their users as they see fit?
We're unfortunately in this weird political moment where everyone agrees that the influence that these companies have over what you can say online is a problem. But ideas about who's being censored are really dramatically different from each other. I mentioned a minute ago this problem of state actors taking advantage of the flagging systems on Facebook in order to essentially game those to have speech they don't like taken offline. This is also a frequent issue with trolls attempting to remove people under sort of extremely broad rules on online platforms. A coworker of mine likes saying, and I have stolen it from her a lot of times, we're not at the beginning of a slippery slope. We are a long ways down that slope already. In terms of the ways that the rules at web platforms can unintentionally or intentionally silence the people who have the least of a voice in mainstream society.
Yeah, because you say that censorship hurts marginalized voices.
Yes. Just to give another example, Facebook recently introduced a new sexual solicitation policy that is, I think there's a good argument that it was created in reaction to SESTA. I don't know that, but it seems like a distinct possibility to me. But it's worded so broadly that it seems like a lot of just discussion about sex could run afoul of the rule the way that it is written. Here's the thing, though. I'm never going to be a victim of that rule because I'm a straight white man. The people who most need a place online where they can talk about issues of sexuality are unfortunately also the people who are most likely to be victimized under kind of online bullying campaigns. And this is why I get so frustrated when I think some people, especially some people in Congress, want to make the focus so much on political neutrality. This is what really bothers me when people want to make the discussion about political bias on these platforms.
For example, I know that there's a lot of grievances from political conservatives saying that they feel like they're being censored more than liberals.
Yeah, and they put on this hearing in Congress where Diamond and Silk, the YouTube celebrities.
I don't even know who they are.
They're these two women who run a YouTube channel who are big fans of Trump, and I think they've even spoken at some of his rallies and things. And there was this whole hearing in Congress about what, if I understand the story correctly, seems to be that their channel was demonetized for a small amount of time because of some kind of miscommunication about the rules. That's what I think the actual underlying story is. But those are the issues, and the accounts of political commentators on the right, that those are the people being censored. Whenever you unfairly ramp up these moderation rules on online platforms, the people who are most likely to be unfairly silenced on those are the people who have the least voice in mainstream society.
Well, so what are your thoughts on the conservative claim that they're being censored? You don't have
The best response I can make to that question really is that, like I said a second ago, we're not at the beginning of a slippery slope. We are a long way down that slippery slope already. And let's talk about the ways that these systems on online platforms have been abused by organized trolls, by state actors. Let's talk about those first.
Well, Elliot, is there anything else that you feel like is important to get out there on what EFF is about and what you guys do, or on the topic of free speech, or anything else?
Actually, there's one other thing that it might be useful for you guys to weave into this, and that's like what EFF has advocated in terms of what platforms should do differently for how they're taking down speech and how they're enforcing their community standards. That might be a useful thing to put into this. We were talking before we started taping about the tragedy in New Zealand the other day, and it is horrifying in every possible way, including the role that the internet played in it.
Do you mind giving a recap for maybe people who don't know the details?
A person killed several people at a mosque. He also put up this manifesto that I actually have not read, but that I understand is just full of these kind of alt-right, in-jokey references.
But he had live streamed
Right,
the
and
whole thing, which I think is the crazy. I mean, the whole thing is crazy, but the most disturbing part of it all.
Whenever a tragedy like this happens, it always leads to calls for platforms to do more to remove certain types of speech. And of course, it's understandable that those calls come in the wake of tragedy. That is a completely understandable response. And unfortunately, as we've been talking about here, the ways that platforms attempt to clamp down more often have really disturbing unintended consequences. We've seen, I think it was Facebook, lots of work by journalists documenting atrocities in Syria being unintentionally removed by these filters. There have been examples of journalists and activists in places like Syria and Vietnam being censored under these kind of anti-extremism filters. So when companies do attempt to kind of ramp up their moderation, they need to really, really carefully think about how those rules and processes can be taken advantage of by trolls and by state actors too. Otherwise, they really risk doing more harm than good. EFF, along with ACLU and a number of other organizations, came together and endorsed this thing called the Santa Clara Principles, that are kind of our principles for how we think that online platforms should enforce their speech policies. And the interesting thing about these principles is that they don't talk about specific content. They don't talk about whether nudity should be allowed or whether certain types of hate speech
It's
or
very
violence
broad.
should be allowed. Well, they're not about the content. They're about the processes. And what we basically ask is three things. One, that they provide actual transparency about how much stuff is being removed under what rules. Two, that they notify you. When you have something removed, they tell you what was removed. They tell you why it was removed.
Specifically.
Yes. They tell you what the rule was that you broke. And three, an actual opportunity to appeal that decision to a real human being. And those are the three things. So, like, it's not that we think that platforms should not have any community standards or that they shouldn't remove anything. But we think that those principles are the way to stave off at least some of the unintended consequences. If you're actually being clear about what you're censoring and why, and then you're giving people the opportunity to appeal when you make a mistake.
Gotcha. Well, Elliot, thank you so much for coming on and giving us a rundown of all of this. I mean, we'll definitely stay tuned in to updates on your guys' work. We'll have to have either you or someone else from your organization to come on to give us those updates or talk about other areas, because I know you guys also talk about online security, privacy, so many areas.
Yeah, we would be happy to be back anytime.
Well, thank you so much.
Thank you.
Hey everyone, thanks so much for watching the episode. If you're interested in contributing to the conversation and supporting the show, there's two easy things you can do. One, click subscribe, and two, visit our Patreon page where you get exclusive access to the Exploring Minds community.